My name is Hannah. One afternoon, a stranger called me to ask when I'd be out of my late father's house, a house I still legally owned. That's how I learned my sister had already sold it. If you've faced a family betrayal like this, share your experience in the comments. The call came from a number I didn't recognize. A man said he was calling about my father's house and asked what day I planned to hand over the keys. He spoke calmly, like this was already settled. I told him there had to be a mistake. He paused, then said, "I'm the buyer. We're scheduled to close this week." The drive to the house in Phoenix felt automatic. The street looked the same, but the yard didn't. A red "sold" sign stood near the mailbox, still crooked from being pushed into dry ground. The front lock wasn't ours anymore. A new one caught the light. My phone buzzed again before I could touch the door. Laura answered on the second ring. "It was time," she said. "For what?" "The house. Papers are done." I asked where my signature was. That question hung there longer than it should have. Laura started talking about how hard things had been, how the family had agreed, how this was cleaner. She said everyone was tired of waiting. The words came fast, like speed could replace consent. A group text lit up. Aunts, cousins, people who hadn't checked on Dad in years. Messages stacked up telling me not to complicate things, not to embarrass Laura, not to turn family business into drama. Someone wrote that Dad would have wanted harmony. No one mentioned the deed. Taped to the front window was a copy of the sales contract. Wind lifted one corner. The last page, the one with signature lines, was missing. A closing date sat near the top, 2 days earlier than the timeline Laura had emailed months ago. That email was still in my inbox. The difference wasn't large, but it mattered. I walked around the side of the house and checked the security panel. The screen said the system was under maintenance. No footage available. Laura had insisted on that system after Dad's health declined. Now it couldn't show who had been there. The buyer texted again, polite but firm, reminding me about the 72-hour window to remove personal items. His message ended with a smiley face, like this was customer service, not a family fight. A separate text came through from Laura. "Just let this go," she wrote. "Dad would want peace." I called the title company number printed on the contract. An automated voice thanked me for calling and said my call was important. It repeated the message when no one picked up. Standing on the porch, phone pressed to my ear, that line played again, steady and cheerful. Another vibration. The buyer. Then my mother. Then a calendar alert marking the closing deadline. The next morning, my phone stayed quiet, which should have felt like relief. Instead, an email arrived from my cousin with the subject line, "Family Update." It wasn't an invitation. It was notes. Bullet points about decisions already made, including the sale, written like meeting minutes. Laura's name appeared next to phrases like "handled paperwork" and "coordinated timeline." My name appeared once, next to "unavailable." At work, I asked my manager for time off. I said there was a family legal issue. He nodded, typed something, and reminded me to log the hours correctly. The system accepted the request without comment. By lunch, a coworker forwarded a link Laura had posted in a private family group. She thanked everyone for trusting her to take care of Dad's affairs and wrote that selling the house was the responsible choice. People replied with heart emojis. Messages followed. An aunt told me not to be greedy. An uncle asked why I was holding things up. Someone suggested I was emotional because I'd moved away. No one asked if the sale was legal. The assumption settled fast. Laura was practical, and I was difficult. In the afternoon, I met Rachel Kim near ASU. She'd worked escrow for years and had known our family casually. She listened without interrupting, then set her cup down. "You're on title, right?" "Yes." "As in listed owner?" "Co-owner, since the refinance." Rachel didn't react. She pulled out her phone and logged into the county recorder system. Her thumb moved fast. After a moment, she tilted the screen toward me. The transfer wasn't there. No completed recording, just a pending entry. "That doesn't mean it won't post," she said. "But it hasn't." "Not yet." She asked for dates, not feelings. When was the refinance? When did Dad sign? When did Laura mention selling? Each answer went into a notes app. Rachel told me to save everything: emails, PDFs, the refinance paperwork, any timeline that showed I existed in the process. Back in the car, I called the title company again. This time, a recorded menu directed me to submit an inquiry through the online portal. The form asked for a reason. I clicked the drop-down: boundary dispute, signature clarification, ownership question. None fit. I picked the closest option and typed a sentence that felt too small for the situation. An automated response arrived immediately. "Thank you for your submission. Someone will contact you within 2 business days." Another email followed, this one forwarded by my mother. Laura explained that delays could jeopardize the sale and hurt everyone. She wrote that Dad would be embarrassed by the conflict. No one replied to that message. Silence counted as agreement. Rachel texted later, asking if I'd checked the closing date. I opened the contract photo from the door. Friday at 3, 2 days away. She responded with a single line: "Then you don't have time to argue." At home, I printed what I had and laid the pages out. The refinance statement showed both names. The email chain showed Laura acknowledging that. The contract still lacked the final page. Each document stayed where it was. Nothing got sorted yet. Another notification came through. This one, official. Escrow confirmation. Closing set for Friday at 3 p.m. Instructions to follow. The message ended with a reminder to arrive early for processing. Before evening, Laura called our mother from my number and left a voicemail meant for me to hear. She spoke carefully, explaining that buyers expected cooperation and that lawyers would only drain money. The message ended with her asking why I couldn't trust her. The voicemail system labeled it saved. An HR email arrived reminding me about confidentiality while on leave. It included a link to policy language and a cheerful sign-off. Reading it felt like being reminded to lower my voice during a fire alarm. Rachel sent another text with a screenshot from the recorder's site. The pending status hadn't changed. She wrote that speed favored whoever controlled the narrative, not the paperwork. Her advice stayed practical. Don't confront, don't warn, don't explain. That night, a cousin knocked on my door unannounced, carrying takeout as peace offering. He said Laura was under pressure and that I should think long-term. When asked if he'd seen the deed, he shook his head and said it didn't matter. Family mattered. After he left, the portal sent another automated message. Your inquiry has been received. Estimated response time, 48 hours. I refreshed the escrow email once more, watched the details load, and the Friday deadline sat there, unchanged. The email was buried far back, the kind of message that only surfaces when everything else has failed. It came from Laura, sent years earlier, with a subject line about hospital paperwork. She'd asked me to review a temporary power of attorney while Dad was admitted. At the time, it sounded routine. The attachment opened slowly now, scanned crooked. The text faded around the edges. Dad's signature sat at the bottom, thin and uneven. There was no notary stamp, no seal, just a date and Laura's name typed in bold above a paragraph about limited authority, temporary, medical decisions only. It had expired long ago. Another message followed that email. Laura thanked me for being flexible and said she'd take care of the rest. That phrase had shown up again and again over the years, always attached to things she didn't want shared. Rachel called while I was still reading. She didn't ask how I was holding up. She asked if I'd found anything new. There was a power of attorney, I said. Expired? Yes. Was it recorded anywhere? No. Then that's how. The way she said it made the answer sound smaller than the damage it caused. Laura had used that old document to open escrow. She'd treated it like a blank check. From her perspective, my signature wasn't missing. It was unnecessary. The conversation from the porch replayed itself differently. The speed, the refusal to answer directly. Laura hadn't been improvising. She'd been confident. Confident enough to skip me. An envelope arrived that afternoon, hand-delivered by courier. Laura's attorney letterhead sat centered at the top. The language accused me of interfering with a lawful sale and warned of consequences if delays continued. The letter cited the power of attorney as authority and framed my actions as disruptive. It requested immediate compliance. My mother called before I could respond. Her voice broke early. "She's under so much stress," she said. "You're making this worse." "She's trying to do the right thing. Please stop." No questions followed, just requests. The call ended with a plea to think about the family's reputation. At the county office, the clerk took the POA copy and scanned it without comment. When I asked if it was valid, she shook her head. "I can't advise on that." "Can you tell me if it's recorded?" That would be legal advice. She stamped the page "Received" and slid it back through the opening. The stamp hit the paper hard, like punctuation. The transaction ended there. Outside, a notification buzzed. The buyer wanted confirmation about access. His message stayed polite, but the spacing between responses had tightened. Time was doing its work. Rachel texted again. "They'll push because it's cheaper than checking." "What do I do?" "You decide where to apply pressure." Without waiting for another answer, I drafted a notice to escrow. It stated that I was a titled owner and disputed the authority used to open the transaction. No accusations, just facts. The email went out with attachments and a timestamp. The response came faster than expected. The buyer called, voice raised, asking why the deal was being sabotaged. He mentioned movers. He mentioned financing. He mentioned lawyers. "I was told this was clear," he said. "I'm saying it's not." The call ended abruptly. An email followed, sharper than the last. If the sale failed, damages would be pursued. Laura texted once more, shorter this time. "You had no right." Another call from my mother went unanswered. Rachel sent a single line, "This will get louder." By evening, the buyer's attorney entered the conversation. The email CC'd everyone involved. The subject line was formal, detached, and heavy enough to change the air in the room. Notice of potential litigation. The cursor blinked at the end of the message while I read the attachments, watched names stack in the thread, and saw how fast a family dispute became a legal one without anyone slowing it down. The freeze came through escrow first, a short email, neutral in tone, stating that funds were being held pending resolution of a dispute. No apology, no explanation. An hour later, another message followed. The buyer had withdrawn the deposit and filed a claim against Laura. The subject line used her full legal name. Seeing it there felt different than seeing it in a family chat. Laura responded fast. A notice from the court arrived by certified email before sunset. She'd filed a petition asking a judge to validate the power of attorney and confirm her authority to sell. The filing framed the situation as confusion caused by an uncooperative sibling. Dates, exhibits, and my name appeared in neat order. The system had picked a side simply because someone moved first. The story Laura told the family traveled faster than the paperwork. Messages spread, repeating the same phrasing. I'd cost everyone the deposit. I'd embarrassed her. I'd made things public. By nightfall, relatives stopped pretending to stay neutral. Comments appeared under old photos. Someone wrote that Dad would be ashamed. Another said I'd always been difficult. The group chat disappeared from my phone. No notification. Just gone. A cousin later texted privately to say Laura needed space and that blocking me was for everyone's peace. The explanation felt rehearsed. Rachel called once the lawsuit became official. She didn't sugarcoat anything. "She's playing speed," she said. "What does that mean?" "She files, she frames, she forces reactions. Truth takes longer." There wasn't a fix she could offer. Her role stayed limited. She pointed out patterns, not exits. Laura knew how to move through forms, deadlines, and default assumptions. Each step created momentum that looked like legitimacy. While checking account alerts, I noticed a billing notice from the security company tied to Dad's house. Service cancellation. The date landed a week before the sold sign went up. A confirmation email sat unopened in Laura's old shared inbox, still accessible through a family account. She'd shut the system off herself. The maintenance excuse hadn't been chance or bad timing. It had been a decision. That detail changed the shape of everything. The broken camera wasn't a coincidence. It was preparation. Another email arrived from Laura's attorney requesting that I stop contacting third parties involved in the sale. The message referenced the pending court petition and warned against further interference. The language carried weight because it followed a filing, not because it was correct. At work, HR asked if the situation might require extended leave. The phrasing was careful. They needed to know whether this would escalate. I said it might. The response came with a link to benefits and a reminder about documentation. Process stayed intact. The buyer's attorney followed up, attaching a draft complaint. My name appeared in a paragraph describing delays, though the claim targeted Laura. Reading it made the consequences feel wider. This wasn't just about a house anymore. It was about who would be blamed for slowing a machine that expected cooperation. Rachel sent one last message that day. She always gets ahead of verification, she wrote. Then what? Then someone has to stop reacting. Direct contact ended after that. Calls went unanswered, messages stayed unread. Any reply would feed the narrative that I was emotional, disruptive, or panicked. Silence wasn't strategy yet, but it was the only move that didn't add fuel. At the courthouse, the clerk accepted Laura's filing and scheduled a preliminary review. The notice arrived electronically with instructions and deadlines. Everything about it felt procedural, even as it rearranged my life. The system didn't pause to ask who started what. Outside, my phone buzzed again. Another relative, another plea to settle privately before lawyers ruined things. No one mentioned the missing signature or the expired authority. Those details moved too slowly to compete with urgency. The realization didn't arrive as a speech or a moment of clarity. It showed up through subtraction. Every attempt to explain made things worse. Every reaction strengthened Laura's position. The path I'd been on assumed fairness would catch up. It wasn't designed for someone moving faster than verification. The car sat parked across from the courthouse. The engine stayed on until it didn't. The building in front of me held files, stamps, and people trained to follow order. Reaching for the laptop felt like the first deliberate action of the day. A new folder appeared on the screen. The cursor hovered while I named it. Receipts. Files began to move into it one by one as the afternoon light shifted across the dashboard, the court schedule ticking forward on my phone, while the directory filled and the next step waited to be chosen. The letter from Laura's attorney arrived by email and certified mail on the same day. The subject line matched the envelope exactly. It demanded that I stop interfering with the sale and route all communication through counsel. The tone was firm, professional, and confident. Reading it didn't change anything on the surface, but it narrowed the options. This was no longer informal pressure. It was formal containment. At work, my role shifted without ceremony. HR explained that ongoing legal distraction required temporary adjustments. Projects moved to other coordinators. Access stayed, authority didn't. No one accused me of anything. The change was framed as support. The effect was isolation. At home, paperwork took over the dining table. Emails printed, attachments labeled, dates highlighted. The refinance documents went first, then the hospital email chain, then the power of attorney scan. Pages stacked by year, then by month. A hole punch clicked steadily, the sound repetitive and final. This was the first time everything sat in one place, ordered instead of scattered. Rachel met me at a small law office she'd used before. She didn't hug me or ask how I was doing. She waited until the attorney stepped out, then asked one question. What do you want the outcome to be? I don't want to fight my family. That's not an outcome. I want the truth to be handled correctly. Then say that. The attorney returned and reviewed the stack without comment. Rachel stayed quiet, letting the documents speak. When the review ended, the attorney asked about the power of attorney. It was temporary, I said. Medical only? Yes. And expired? Yes. Rachel leaned forward. The notary on that document, she said, is no longer licensed. That name hadn't meant anything before. Hearing it now changed the tone of the room. The attorney asked how she knew. Rachel pulled up a public registry and slid the phone across the table. The notary's license had been revoked years ago. The date matched the scan. The cost became clearer in that moment. Proceeding meant escalation. Family conversations would turn into depositions. Private pressure would become public record. Laura's version of events would be tested, not discussed. Back at the apartment, my phone filled with missed calls. My mother left a voicemail asking me to reconsider before things went too far. A cousin texted that lawyers always win and families always lose. None of them asked what the paperwork showed. They were reacting to movement, not facts. The dining table stayed covered. New folders appeared. One labeled correspondence, one labeled court filings. The power of attorney went into a separate sleeve. The notary registry printout slid behind it. The order mattered now. Rachel texted a reminder to stay narrow. Don't correct the story, she wrote. Correct the record. The next letter from Laura's attorney repeated the demand to stop. It warned of consequences if I continued. The language assumed retreat. It assumed shame. It assumed I wanted approval. I didn't reply. Instead, an appointment appeared on my calendar. Consultation confirmed. Filing window reserved. The attorney's assistant sent instructions about signatures and identification. Everything moved through portals and confirmations. No one asked about feelings. The process only cared about completeness. At work, a colleague asked quietly if things were settling down. I said they were moving forward. The answer satisfied her. No one pressed. The last conversation with Rachel that day stayed short. You're choosing process over peace, she said. I'm choosing process over noise. That's cleaner. Evening came without resolution. The table remained occupied. The printer ran out of ink halfway through a scan, forcing a pause. Replacing the cartridge felt like maintenance, not crisis. When the attorney sent the engagement agreement, it arrived with a checklist. Review, sign, return. Each step sat in its own box. The fee schedule was clear. The new documents arrived through the court portal just after breakfast. They weren't long, but they were enough to shift the balance. Laura had filed supplemental exhibits, each one labeled cleanly, each one designed to slow things down. The attachments included bank statements, declarations, and a revised timeline that made her look careful and thorough. My response packet stayed marked as pending review. One exhibit stood out. It referenced a prior transaction tied to the same power of attorney. Not the house, something earlier. A short-term loan taken out years ago, repaid quickly, barely visible unless you knew where to look. Then another reference appeared, buried in a footnote. The pattern formed without commentary. Laura hadn't used the document once. She'd used it whenever she needed to move money fast. The explanation she'd given the family about hospital bills didn't line up anymore. Those bills had been covered by insurance. The urgency hadn't come from medical debt. It had come from an investment she'd never mentioned, one that went bad right before the sale. The house wasn't sold to simplify things. It was sold to plug a hole. The closing date made sense now, too. A credit review was scheduled through one of the lenders involved in her other ventures. Friday at 3 wasn't arbitrary. It was a deadline meant to outrun scrutiny. Laura's attorney followed up with a notice stating that additional evidence required time for verification. My filings stayed in limbo. The court hadn't rejected them, but it hadn't accepted them either. Everything waited in a holding pattern that favored whoever had already moved. A declaration from a former colleague appeared next. The witness stated that the power of attorney had looked valid at the time of signing. The wording stopped short of confirmation but leaned in that direction. The name was familiar. Someone Laura had once worked with, now positioned as neutral. Family reaction hardened after that. Calls stopped. Messages turned short. A group email circulated warning against airing disputes publicly. The tone suggested that the damage was already done and that I was responsible for continuing it. At work, my access stayed limited. The temporary adjustment stretched into something less defined. No one said it would last. No one said it wouldn't. Meetings went on without me. Updates arrived afterward, summarized and complete. Rachel checked in with a single question. "Did you see the filings?" "Yes." "She's widening the field." "So am I." "Then expect pushback." There wasn't panic in the exchange, just calibration. Rachel forwarded a copy of the Notary Board's disciplinary notice again, this time highlighting the date and license number. It still mattered, it just wasn't enough yet. The court notice arrived before lunch. The judge had scheduled a preliminary hearing. The order listed issues to be addressed and deadlines for submissions. Laura's filings were cited as timely. Mine were noted as under review. The date sat 2 weeks out. Long enough for narratives to settle. Notes went into the folder. Each inconsistency got its own line. The expired authority, the missing notary seal, the prior loan, the timing overlap with the credit review. No conclusions, just alignment. Another message from Laura's attorney arrived, offering to discuss settlement options. The language suggested generosity. It implied that continuing would be costly for everyone involved. The offer came with a deadline. It stayed unanswered. A cousin reached out privately, saying the family was worried about reputational harm. He asked if I could pause things until emotions cooled. When asked whether he'd read the filings, he admitted he hadn't. That wasn't necessary, he said. The process itself was the problem. The court portal updated again. Status unchanged. Pending verification. Rachel sent a screenshot of a public docket from another case involving the same witness. The context wasn't identical, but the pattern was familiar. Support shifted when pressure increased. By evening, the realization settled in fully. This wasn't about one decision or one document. It was about scale. Laura hadn't crossed a line impulsively. She'd been stepping over it, carefully, repeatedly, counting on speed and silence. Dinner went untouched. The laptop stayed open. Each file moved into place, labels adjusted, dates cross-checked. Nothing dramatic happened. The work stayed methodical. The court notification chimed again. Hearing confirmed. Location assigned. Instructions attached. Laura's name appeared first in the caption. Mine followed. The calendar updated automatically. The event blocked out half the day. The time until then felt both short and long. Enough space for more filings, enough room for another shift. Rachel's last message that night came without commentary, just a link to the hearing schedule and a reminder to upload exhibits early. The courthouse opened early, but the hallway outside the hearing room was already full. Lawyers checked phones. Clerks rolled carts past without looking up. Names were called in an order that didn't match the weight of what they carried. When our case number appeared on the screen, Laura stood first. Her attorney followed, already speaking. Inside the room, everything moved by sequence. The judge confirmed appearances. The clerk read the matter into the record. No one asked why a family was there. It was treated like what it had become, a dispute over authority and timing. My attorney spoke briefly, framing the issue narrowly. No background, no family history, just a challenge to the validity of the power of attorney used to open escrow. Laura's attorney responded with confidence. The document was relied upon in good faith, he said. It appeared valid at the time. Laura didn't look at me. Her focus stayed forward, hands folded, posture steady. The judge asked for exhibits. The first packet went up. Email logs. Dates highlighted. The message from years earlier showing the power of attorney was temporary. Another message acknowledging its limited scope. A final email confirming its expiration. Each page carried a timestamp. The clerk marked them and passed them forward. Laura's attorney leaned in. These communications reflect administrative oversight, he said. They don't negate the authority relied upon. The judge nodded once and asked for clarification. Laura's attorney continued, describing standard practice and reasonable reliance. The words sounded practiced, familiar. Then the second packet went up. This one was thinner, a single-page printout from the notary board. License number, revocation date, public record. The notary who'd stamped the power of attorney had lost their license before the document was ever used. Laura's attorney paused. "That information hasn't been authenticated," he said. My attorney responded by handing over the verification receipt. The clerk confirmed it had been submitted with the filing. The judge looked down again, then back up. At that moment, the courtroom audio system chimed. Recording resumed. The judge raised a hand. "Pause for clarification," he said, while the system continued announcing that everything was, in fact, being recorded. No one laughed. The timing was off enough to land anyway. The judge asked Laura's attorney if he disputed the revocation. He didn't answer immediately. He asked for a moment to review the document. The room waited. When he spoke again, the tone had changed. "We were not aware of this issue," he said. "It doesn't alter the intent of—" The judge interrupted. "It alters authority," he said. The ruling came without drama. The power of attorney was deemed invalid for purposes of the sale. The escrow opened under it was improper. My counterclaim was accepted for review. The matter would proceed. Laura's posture shifted. Not much. Enough. Outside the hearing room, the hallway filled again. Lawyers separated. Phones came out. A clerk approached Laura with a packet and asked her to confirm her name. She did. The clerk handed over the documents and explained the next steps. Laura's attorney started to speak, but the clerk had already moved on. My attorney nodded once and said we'd be in touch. There was nothing celebratory about it, just acknowledgement. As Laura walked down the hall, she didn't look back. The packet stayed tucked under her arm. The clerk's voice echoed briefly as another name was called. Another case moved forward. The elevator doors opened. People stepped in. Someone asked which floor. Laura pressed the button without answering. I stayed where I was. A notification buzzed on my phone. The court portal had updated. Status changed. Counterclaim accepted. Another buzz followed. A message from the buyer's attorney asking for clarification about the ruling. No tone, just process. My attorney spoke quietly. "This isn't over," he said. "I know." Across the hall, Laura stopped near a bench and opened the packet. Pages shifted. Her attorney leaned in, speaking quickly. A court officer passed and reminded them not to block the walkway. Nothing about it felt personal anymore. The system had taken over. The clerk returned with another set of papers and asked Laura to sign for receipt. She did. The pen hovered for a second, then moved. The clerk tore off a copy and handed it back. As they walked away, the door to the hearing room closed behind me. The sound carried longer than expected. The hallway cleared. The screen updated to the next case. My attorney checked his watch and said we should file the supplemental exhibits before noon. He turned toward the exit, already planning the next steps. Behind us, the clerk's voice rose again, calling another name, another number, another dispute moving forward on schedule, while the paperwork from ours continued to circulate. The receipt, stamped, delivered, and already part of the record. The buyer's lawsuit moved forward without me. Laura was listed as the primary defendant, her name repeated across filings and scheduling notices. Each update arrived through the court portal with the same neutral tone, outlining next steps and deadlines. The house wasn't mentioned anymore as an asset changing hands. It appeared as a failed transaction, a reference point for damages and claims. The sale existed now only as paperwork. Family communication shifted into absence. No one defended Laura out loud. No one apologized either. Messages stopped arriving altogether. Group chats stayed silent. When relatives spoke to each other, it wasn't where I could see it. The quiet felt heavier than the arguing ever had. Laura texted one afternoon, "Can we talk privately?" The message sat there for a few minutes. It didn't ask about the case or the house. It didn't mention the lawsuit. Just a request, stripped of explanation. I replied once, "Please direct all communication through counsel." No follow-up came. The typing bubble never appeared. A new phone number went live that evening. The old one stayed active long enough to forward essential contacts. Family numbers didn't make the cut. One emergency contact remained, marked clearly. Everything else moved to the archive. Receipts finished uploading overnight. The cloud folder synced page by page, each file time-stamped and labeled. Contracts, emails, registry screenshots, logs. The system confirmed completion without comment. The local copies stayed organized but unused, backups of backups. The county trustee's office accepted walk-ins during limited hours. The line moved quickly. Most people came with envelopes and questions. When my turn came, the clerk asked for identification and reason for visit. "Property keys," I said. She handed over a form and pointed to the signature line. No questions followed. The keys sat heavy in my palm, the last physical link to the house that hadn't changed hands. Placing them in the intake tray felt procedural, like returning library books late. The clerk checked the form, stamped it, and slid the receipt across the counter. "Anything else?" she asked. No. Outside, a notification buzzed. The county system confirmed the submission. "Your submission is complete." The words sat there, perfectly aligned. The walk back to the car took longer than expected. Not because of hesitation, because the parking lot was full and someone had blocked the aisle while loading boxes. Life kept moving around the edges of the situation, unbothered by the paperwork it created. Rachel called later that day. She didn't ask for details. "It's moving," she said. "Yes." "You did what you needed to." "I did what the process allowed." She didn't respond to that. She didn't need to. At work, access was restored gradually. Projects returned. Authority followed after. No one asked for a debrief. The assumption seemed to be that things had stabilized. That was close enough to true. The buyer's attorney sent a brief email confirming receipt of the ruling and requesting updated contact information for Laura's counsel. The tone stayed businesslike. Whatever anger had existed now lived somewhere else. One evening, my mother called from a different number. The call went unanswered. A voicemail followed, short and careful. She said she hoped I was okay and that everyone needed time. No request came with it. The phone stayed face down, laundry finished, dishes dried. The apartment returned to its usual order. Without paperwork covering every surface, the space felt larger, emptier but functional. Another update arrived from the court portal. Scheduling conference set, Laura's case continued. My involvement was listed as interested party, not defendant. The distinction mattered. The cloud folder sent a final notification confirming redundancy checks. All files verified. At the end of the day, the receipt from the county office sat folded in my bag. It didn't need saving. The record existed elsewhere now, stored and indexed. Walking past the courthouse on the way home, the building looked the same as it always had. People entered and exited without pausing. Cases began and ended out of sight. The keys were gone. The folder was closed. Messages stayed unanswered. Another notification lit the screen as I reached the corner. System update complete. The phone slipped back into my pocket while traffic moved forward, the day continuing without waiting for anything else to be explained or returned.